Just real quickly.
Yes.
Today we are diving into not one but two explosive courtroom moments you will not believe. First up, Mr. Hernandez shows up to court high on meth, straight up admitting to using despite knowing he had a hearing. The judge instantly locks in. No excuses, no delays, just action. But then we jump into a shocking neglect case where a 2-year-old child ends up outside in freezing weather wearing only a diaper. That case gets real emotional, real fast. The mother cries. The judge questions everything. And just when you think she is going to jail, there is a twist. You will hear bold confessions, gut-wrenching explanations, and one of the most intense probation rulings we have seen all month. But the real question is, who should be held accountable? Are these just tragic mistakes or patterns of recklessness? Stay locked in, because we are breaking down the rulings, analyzing every move, and giving you the legal insight, emotion, and commentary you come here for. And do not forget, we want to hear from you. Whose side are you on by the end of this? Let's get into it.
The last 3 times I've been in here, you made a reference. And so
Okay.
about suspenders.
Yes. Once Upon a Time in the West. Thank you. With Henry Fonda. Yeah. You know what? That is one of the best Westerns
It is.
that has ever been made. And so few people have seen it.
I agree. Anyway, I was just.
Thank you. That is so true.
Yeah, I have full experience.
Okay. Just one second. Let me write this note. All right. Mr. Hernandez, how are you doing today?
Here we go. Mr. Hernandez steps up, and the judge is not playing around. You can already sense it. That polite, "How are you today?" is just the calm before the storm. Because what follows? A drug admission that is honestly mind-blowing. Imagine being scheduled for court, a place where your freedom is on the line, and deciding to use meth anyway. Not just once, but multiple times a week. It is a bold move, or a desperate one. And when the judge starts pressing for details, he almost laughs it off. But this judge is laser focused. She is not here for jokes. And you heard it. Custody is coming. Court-ordered treatment, a full UA. And this is not about punishment. This is about saving a man from himself, if he is willing. Question for you: if someone shows up high to court, should they still be given treatment, or straight time behind bars?
Oh, I'm doing great. All right. When you drug tested today, what are the results going to be?
I'll probably say positive.
Positive for what? Could everyone please whisper? All right. How often are you using meth? No, it has to be, you knew you were coming to court today. So for you to be positive for meth, that means you used knowing you had to be in court today. So again, how often are you using?
Not often.
What does that mean?
Let's say 3 times a week.
All right. That's often. All right. So we're going to try to get you some help. We're going to do a UA today. And you're going to be taken into custody today. And we're going to try to get you some inpatient treatment, okay? All right. Can you UA him, please? Zane Hernandez. All right. So, Mr. Hernandez, we're going to make sure you have treatment, because you using meth that amount of time, it's not going to end well for you. All right. Do you have children? All right. Where are you staying? Are you staying with someone? Your mom? All right. So we'll be sure to make sure that we have your mother's number and let her know. And we're going to get an attorney appointed for you before you leave here today. Okay. All right. So we can do the UA, and if you can issue file a motion to revoke. And I'm not doing this as a punishment to you. I'm doing it so that hopefully you will become clean and sober, because otherwise it's not going to end well. And when you think that using meth 3 times a week is not a lot, that's a lot. Okay? All right. Thank you.
Switching gears, but not for long. Now we enter a new case, and the stakes are even higher. Meet Kayla Ragg. At first, things look pretty hopeful. A child protective services worker is about to testify on her behalf. And by all accounts, Kayla has been doing everything right. Parenting classes, drug tests, positive reports across the board. But do not get too comfortable. This case is about to take a hard turn. Because beneath all the progress is one disturbing truth. A 2-year-old child was found outside alone, nearly naked, in the middle of November. This is where courtroom drama hits real life. Is Kayla a changed mother, or someone covering up dangerous neglect? Keep watching, because what starts as a redemption arc is about to run headfirst into some harsh reality, and some brutal truths are coming.
All right. If I could see the parties back on ROLAG, please. Okay. Yeah. Is the attorney here for, thank you, counsel. All right, so we're back on the record in 2022 CR 9351, State of Texas versus Kayla Rolag. And you're still under oath. And could you restate your name, please?
Yes, Cynthia Cisneros.
All right, and standing in for the state?
Ruben Herrera for the state, Your Honor.
All right, counsel, you may proceed.
You stated your name. What is your profession, occupation?
Yes, I'm a family-based safety services worker for Child Protective Services.
And have you supervised or participated with Miss Kayla?
Yes, sir. I have been her worker since September of 2022, and her case just recently closed here in February.
Okay, and can you tell the court how you have interacted with Miss Kayla and how has she progressed?
Sure. So, part of my job is to obviously, go into the home, make sure, things are going well with her and her daughter, also to comply with services. So specifically, we had enrolled Kayla Rolag into parenting, domestic violence, and random drug screenings. She excelled the whole time. She also got protective daycare for her child. So that's where she currently is during the day. And then she does reside with maternal grandmother and Kayla during the day. But she did really, really well. All drug screens came back negative for all substances. She was compliant in all of her services, received positive feedback from all her providers. And my time in working with Ms. Rolag, I really did not experience any negative feedback, any negative experiences or anything like that.
All right. And are you fully satisfied that she has participated well then?
Yes, definitely.
As a witness?
Mrs. Cisneros, does the defendant have a support system in order to help her care for the victim in this case?
Yes.
And is she? Nothing further, witness, Your Honor.
Now that was a glowing review, right? The CPS worker just laid out a perfect recovery story. Negative drug tests, program completions, cooperative behavior. Honestly, if you only watched this part, you would think this case is open and shut in Kayla's favor. But here's where you need to be sharp. Court cases are not decided just on improvements. They are judged based on the original offense too. And we are talking about a child, a toddler, wandering outside alone in the cold. You can bet the judge has not forgotten that. This is the classic courtroom tension. Can rehabilitation erase recklessness, or should consequences still apply? What do you think? Should past mistakes define your fate, even if you've turned your life around?
All right. So how long did you supervise her?
Oh, since September of 2022.
And how often were you seeing her?
I was seeing her about twice a month.
All right. And when's the last time she had a drug test?
February of this year.
All right. Thank you.
Thank you.
Your Honor, if I may, Ms. Kayla would like the court.
State, have you reviewed the documentations he wants to present to the court?
No, did the world treat you bad?
I have no objection to the presentation of state stock or the defense documents.
Pepper?
Yes. Thank you, counsel. And for the record, the court is reviewing certificates that have been offered on behalf of Ms. Rolick by her attorney.
That the defendant seems to be taking some steps in,
All right, you all need to whisper in the box.
taking responsibility for this matter. Based on the allegations, Your Honor, it shows a gross negligence and the lack of proper judgment. In fact, that the defendant did admit to leaving her child purposefully at the home without checking to see if there was anybody there to supervise the child, Your Honor. This resulted in the victim child being able to escape the residence on her own, being outside in cold temperatures with nothing but a diaper on. Based on the allegations, Your Honor, the state would oppose the defendant's application.
All right, is there a reason for the tears? Because what he's just saying is true.
Whoa, did you catch that? The judge just laid down the harshest truth of this case. Tears do not sway the court. And honestly, that line is, you can feel the emotional momentum shift instantly. This is no longer about Kayla's compliance with classes or clean tests. It is about accountability, cold, brutal, and real. A child in a diaper, in November, outside, alone. The judge is done with excuses. The court wants to know how could anyone let that happen, and the emotional tear defense. Not flying here. This is one of the realest judge moments we have seen. She is not being cruel. She is demanding responsibility. Question for you. Do you think Kayla is being sincere, or just trying to soften the blow before sentencing?
No. Now, I know people want to cry before the court because they want the court to be lenient, but let me just tell you, tears don't sway the court. I'm just here to listen to facts to see if you've done anything that would justify the court placing you on probation. Okay? All right. So that's why you're asking for her to go to prison?
Yes, Your Honor.
All right. And have you State, have you had a chance to review her certificates?
I did, Your Honor.
All right. All right. Defense?
Yes, sir. And, Your Honor, we're asking that the court consider supervision for her. This offense, first of all, the child just wandered away from, in contrast to what counsel says that the child escaped. So it wasn't a matter of escaping. She was just wandered off as children off too. My client had stated, she told the police that she thought that the adults were inside the home and that the child was being taken care of. And it was just a mistake on her part. And I would like for Ms. Rolick to address the court on this issue of abandoning the child.
All right. Can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right. You can lower your hand, state your name for the record.
Kayla Roloff.
All right. Defense?
And why do you, first of all, Was this an honest mistake on your part in leaving the child?
Now it is Kayla's turn to speak, and this is what we live for in court commentary. This is the raw, unscripted confession moment where everything hangs in the balance. We have seen defendants break down. We have seen them lie. But what you are about to hear, it might just surprise you, because Kayla does something rare. She admits fault. She says, "This is my fault. I take full responsibility. No more blaming others." But is it too late? This is where it gets tricky. She admits she assumed someone else was home, but did not check. And that assumption nearly cost her child's life. If you were the judge, would her admission change your mind? Or is recklessness still recklessness, even if the heart is in the right place?
Yes, I would never want to leave my child on purpose. I take care of her every day. I'm the only person that she's been with every day of her life. I love her and I didn't mean to put her in any harm's way.
All right, somebody want to explain to me, the crux of this entire situation is some kind of way, a 2-year-old in a diaper ended up wandering the streets in a diaper only in November, and it was cold. So, I mean, that's what we need to get to the point of, because in the PSI report, she's blaming the people who CPS has put in charge of helping her supervise the child. That's who she's blaming for her child being out and about, because in the PSI report, it states that guilt was minimized. And in the PSI report, she's stating she thought these other people who CPS put in charge of her child as the person to chaperone or supervise, she's blaming them, saying that they were supposed to be there. So somebody explain to me how a 2-year-old gets out of a apartment or residence that's supposedly locked or should have been locked.
So she was naked, not wearing any clothes, because that's how we sleep. She still goes and runs around naked. We just got out of diapers, so she usually just wears a underwear, but that's why she was naked, not having any clothes. And I do not blame anyone else. This is my fault. I should have been the one to check if anyone was there. I was just saying that I had thought, because when I had laid down my daughter, my mom and my uncle were still there. So that's the reason why I didn't check. But this is my fault. I am taking full responsibility.
Okay, that's
You can feel the weight in the room now, can't you? Kayla just poured out her version of events. And to be fair, she is not dodging blame anymore, but the judge, not letting up. What we are seeing is a legal reality check. The court is not just listening to what you say, but how much sense it makes. And Kayla's version, assuming her mom was still there, not checking, not knocking, it is raising serious doubts. Because let's be honest, most parents would double check if their kid is safe before stepping out. Do you buy her story, or do you think she is trying to rewrite the facts now that she is face to face with consequences? This is a real test of judgment and trust. The court is about to decide if Kayla is a danger or just a deeply flawed human trying to do better.
I hope everybody understands. I'm always curious. I have questions. It sounds odd to me, unless people are living in a mansion and you have the West Wing and the East Wing, and people leave and people don't know it. So I'm just finding it, or I just have questions. How a child gets left, and I don't even understand how children get left in the car by themselves, but in a home, how does a child get left in a home by themselves if a parent is leaving and other people are there and other people see you leave? Nobody thinks, oh, we can't leave because there's a 2-year-old here. How does that work?
So when I laid down my daughter, my mom and I both went into our rooms. That's why I thought that she was there. So I didn't hear no door open or close, and I hadn't come out of. So I didn't see anybody. I figured my mom was still home because I didn't see anybody out there.
So you don't see anybody and you just leave your daughter in a house and you haven't seen anyone?
Just because I thought that my mom was in her room still.
Defense, you may continue.
I have no further questions, Your Honor.
Any questions?
Just briefly, Ms. Rowlett, how far away is your mother's room from your room?
It was down low.
Did you knock at all to check if she was still there?
I don't think so.
Did you walk around the apartment to confirm that there was any adults present before you left the apartment?
The prosecutor is poking holes in every detail now. Distance to her mother's room, whether she knocked, whether she even saw an adult before leaving the house. These questions are not just technicalities. They are aimed at one thing: credibility. This is courtroom chess. Every time Kayla says, "I thought" or "I assumed," the state hears negligence. The judge needs facts, not feelings. And right now, the state is building a case that Kayla chose convenience over caution. Would you risk your child's safety on assumptions, or always make sure, no matter what? This is not about punishing a mother. It is about making sure this never happens again.
I just walked through the living room.
All right. Any other witness defense?
No, Your Honor.
All right, I want a UA today, then I'll make my decision. All right. So, Ms. Abrams, if I could have a UA on Ms. Rolak, please. Motions on the bond that goes with that. This is done. All right, could I see the parties on Rolak? All right, we're back on the record in 2022 CR 9351, State of Texas versus Kayla Rolak. Court is here. Counsel. Thank you. All right, we're back on the record in 2022 CR 9351, Kayla Rolak. And the court asked the defendant to do a UA. And I'm very happy to say that the UA was negative.
Okay, let's take a breath. Big win just landed for Kayla. The drug test came back negative. In this courtroom, that is huge. It gives her a little credibility back. It tells the court she is staying clean. It is not everything, but it matters. And yet, when her attorney asks to remove the monitor, denied. Why? Because even progress must be proven over time. This is a reminder. Just because someone is doing well now does not mean they are out of the woods. The court needs consistency, not just moments of clarity. Do you think she should have earned a little more trust at this point? Or is the court right to keep the pressure on?
All right, is there anything else from either side with regards to argument?
Nothing from the state, Your Honor.
Anything else from the defense?
Well, no, I have a request, but
What is your request?
she's been on the monitor for 5 months. We're asking if it can be removed.
Oh, she's going to remain on the monitor. All right. So, Ms. Rolek, I wanted to tell you, and this is why I always keep an open mind on everything. Just reading your history and looking at everything, someone would suggest that you should go to prison. But, I always tell people whether you think a judge is going to do something or not, and I would always tell my clients, hey, you know what? We have to give the judge something to suggest you're not going to prison. So don't come in and throw yourself on the mercy of the court and you have done nothing. You understand? So I see that you've done a lot. I see that you completed everything with Child Protective Services. And sometimes Child Protective Services, they're always overworked and underpaid, but you actually had a good caseworker to stay on top of you and make sure that you were doing everything that you were supposed to be doing. And I see that during this time, you got your GED, you're enrolled in college. That's great.
This is the kind of ruling that gives you goosebumps. The judge is laying out not just a verdict, but a philosophy. She talks about second chances, hard work, and the power of redemption. And when she says, give the judge something to work with, she means it. Kayla did. She completed classes, got her GED, enrolled in college, lived with supervision. She did the work, and now the court responds with a massive decision, deferred adjudication. That means no conviction on her record if she sticks to every single rule. But here's the twist. The judge also sets strict boundaries. No adult males in the house. Continued supervision. Monthly visits. The message is clear. We believe in you, but we are watching. Fair deal, or still too harsh. The court is giving her a lifeline, but it is on Kayla now to prove it was worth it.
To all the children who are out there who always think that the best college to go to is someplace that's not at home. Sometimes, you know, the best college is a college that's actually in your city. People always want to go to some other college because they think it's the best college. And I always say the best college is wherever you are if you make it that best college. So I see that you've done that. You have supervision because you're not living by yourself. I'm going to want you to continue to not live by yourself. Now, once you've been on probation for a while, your attorney can always come back and ask the court to reconsider that part. So who are the persons you're living with?
I live with my mom
Okay.
and my daughter,
And what's your mom's name?
Brenda Marshall.
I'm sorry?
Brenda Marshall.
Brenda Marshall. And I'm assuming your mom wants you to remain with her.
Yeah.
All right. So this is what the court is going to do. The court is going to grant your application. And I'm actually going to give you deferred adjudication. So 4 years deferred adjudication. There's to be a $1,500 fine. That will be probated. Taking consideration, County Court Cause number 688-620-691-438, Night Mag number 675530, proof of employment within 30 days. And in this court, if you're on probation here, I don't allow you to be a home health care provider. So there's to be no employment as a home health care provider with minors. 250 hours community service restitution. Those hours will be waived if you provide proof of enrollment in college, which you have. You need to provide that proof to probation today. And for the court to give you credit for that, you need to take at least 9 hours a semester. And I don't allow people to do that thing where they say, oh, here's my 9 hours for semester, and then they drop classes. That's expensive.
Can I say something?
Yes.
I actually am going for a pre-major in psychology, and then I want to go to UTSA. So after these, I'm going to do I think around 17 hours a semester because I'm.
Thank you. See, when I tell people that every semester I would do 24 hours a semester, people don't believe it, but it can be done.
Yeah.
All right. So provide proof of enrollment in college with at least 9 hours. Probation, I'm going to ask for parenting classes. She's already completed those. So you'll need to provide documentation to that.
The terms of this probation are no joke. The judge is tailoring every condition based on experience. No home health jobs, no dropping classes, no unsupervised male roommates. Every detail is about protecting the child first. This is not just sentencing. This is the system trying to build a better future for both mother and daughter. And you heard that exchange, right? Kayla is not just accepting conditions. She is asking for more parenting classes, counseling, therapy. That is rare. It shows she is not just looking to escape punishment. She genuinely wants to grow. That might be what tipped this case in her favor. Do you think the system should offer more support like this in every case?
She is to reside with Brenda Marshall. And so it's only you two in the household, right? All right. There to be no adult males in the household residing there.
Okay.
If something changes, you can let me know. I just found from my experience as a defense attorney on CPS side, what ends up happening is mothers are doing great. And I've had male clients over there too. They're doing great. Then the next thing you know, they end up getting a new partner. They don't vet that partner appropriate, and everything that goes downhill. So that's why I'm putting no adult males. So she's not allowed to reside with any adult males. Probation, I'm going to want field visits once per month. Regular reporting, and the field visit can count as her reporting, and that field visit is until further notice. And we'll do regular UAs. Probation, is there anything else she needs?
No, Your Honor.
Is there anything else you need from the court to be successful?
If, I know you said I could take my certificate that I already did parenting class.
Yes.
Can I still take another one? Because this last one that I took with the San Antonio Fatherhood Campaign,
Mhm.
I actually learned a lot. And if I could just keep learning, because my daughter is getting older.
Okay.
And also, is there any way that I can get, that y'all can help me with like therapy or like getting into counseling?
All right. So what I'll do is probation, we'll add parenting classes. And make sure you notate in that the parenting classes were at Ms. Roleg's request. And also, do we need a mental health caseload or mental health evaluation probation?
What's your mental health evaluation for referral just to sit on my
All right, we'll do a mental health evaluation for referral.
I did do that, and she said that I didn't have any like things, but I have a lot of anxiety and I just deal with a lot of stress and stuff. So that's why I asked for like the therapy or counseling.
All right, they'll take care of it. They're going to make it happen. If it doesn't happen, let me know.
Okay.
I'm here.
And there it is, a final reminder that the court is not closing the book just yet. Probation will track her. GPS monitor stays on for 2 more months, and even her trips to the park must be logged. That level of control might sound extreme, but after what happened, the court is not taking any chances. Still, there is a noticeable shift here. Kayla is thanking the judge, smiling, grateful. That is a big turnaround from the tears earlier. You can tell this ruling gave her something she did not expect: hope. The court is saying, we believe you can do better. Prove it. And that right there is why courtroom moments like this matter.
All right, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it, and did you sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. All right? All right, good luck to you. Good job.
Thank you so much. Thank you so much.
Oh, you're welcome.
Your Honor,
Yes.
did you specify?
Wait, am I still on house arrest?
Oh. With regards to the monitor probation,
Yes, Your Honor.
let's keep her on the monitor for 2 months. If there are no issues, then it can be removed.
GPS partial.
Yes.
Like, can I take my daughter to the park and stuff?
Yes, it's probation. Just make it tracking,
All right.
Thank
but
you
you'll
so
still
much.
need to let probation know where you're going to be, okay?
Okay, thank you so much.
You're welcome. And this is, the top copy is for the state. All right, thank you.
Have a good
Just,
week.
oh, thank you. Just remain in the, she needs.
What a ride. 2 very different cases. 1 courtroom. Mr. Hernandez walked in admitting to meth used the same day as his court appearance. The court responded swiftly. Custody and treatment, not as punishment, but as a shot at saving his life. Then came Kayla Ragg, a mother whose child ended up outside in the cold. She was accused of negligence, faced the wrath of the judge, and stood at the edge of prison time. But she fought her way back with clean tests, parenting programs, and real progress. In the end, the judge gave her 4 years of deferred adjudication, a second chance, with strict conditions. And that is what makes this case unforgettable. It is not just about crime or punishment. It is about accountability, transformation, and the hard decisions courts make every day. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and subscribe for more jaw-dropping courtroom breakdowns. You never know what will happen next, but we will be here to break it all down.